Thank you for viewing our COVID-19 and Your Community webinar recorded on March 31st, 2020. I want to give special thanks to Austin Barcelou and Cipra Boyd for dedicating their time to present on this very important topic. CAI exists to provide education and resources to our members. For more information, visit caihouston.org. Now let's get right into the presentation.
Good afternoon, everyone, and thank you so much for attending the webinar. I know this is a new time and a new life for us, so appreciate Jesus reaching out to us to do this and in this capacity. Just want to thank everyone for joining us. Hope everyone's staying safe and healthy and practicing your social distancing, physical distancing procedures. So today we're going to talk about several topics. The first thing that we're going to discuss is the community association's role with respect to some of the functions that it does and how those are impacted with the current situation. Some of the main functions of the community association, and we're going to provide legal advice about how to handle those. What to do if you know about a positive COVID-19 test or have heard that there is one in your community or in your high-rise. We're going to spend a little bit of time talking about the shelter-in-place, stay-at-home orders, and just discussing what potentially we consider our essential services from the community association perspective. We're going to touch real lightly on the labor and employment issue. I know there are certain acts that have been implemented that do affect associations with employees and management companies, but neither I nor Austin are labor and employment lawyers, so we'll just kind of give you some resources on where to go for those. And then we'll conclude hopefully within the next 30 minutes or so, so that we have plenty of time to ask questions at the end. The presentation is intended to cover single family, townhome, condos, high-rise, mixed master use, and then also commercial associations. There's certainly a limited amount of law as it relates to commercial associations, but I think the information that we present here today should be used by everyone as a best practice, even if maybe the law is not exactly on point. This certainly is not an exhaustive presentation in terms of the information that we have to present in connection with how COVID-19 impacts the community associations. So make sure you reach out to your attorneys and ask for advice whenever you deem it's necessary. It's a real fluid situation. As we just learned, Harris County just extended their shelter-in-place order, so our advice is constantly changing. All right, so the community association's role. I wanted to start here mostly because the ultimate message from a legal perspective is that we want the association to stay within its scope of authority. And that comes from the association's either certificate of certificate of formation or articles of incorporation. Those are the inception documents for the association. And within those documents, for that document, you will find the general purposes of the association. And for most associations, most recent ones anyway, some of the older ones from the 60s and 70s might not necessarily have this, but most associations, certificate of formations, mandate that the purpose of the association is to protect and preserve values. And that's basically the main purpose of any association. For associations that have certificates of formation or articles of incorporation that also list that a purpose is to protect the health, safety, and welfare of its residents, I want y'all to be mindful that if that's in there, you might need to reach out to your attorney to determine how best to disseminate information, because I think that you probably need to get legal guidance on what information you should share and what you probably shouldn't. From the perspective of the association's main function and the fact that it's to preserve and protect property values, and being that that's the main scope, we want to kind of give you legal advice to limit the potential for liability. If the association, the board, the management company goes beyond the scope of protecting and preserving property values, then of course you subject yourself to liability. A second function of an association, and it's really important, especially in times of a crisis, hurricanes or flood events, and pandemics, as we're seeing here.
I'm watching a webinar with
I think someone's,
CAI.
someone's not on mute, sorry.
All right, I got him.
One other purpose of the association is to educate its residents. I know that residents often come to the association in times of crisis because it's kind of a central repository of information. And so they look to the association for that information. And sometimes just, I think associations provide a calming effect when residents can come to the association and give important information. In terms of educating, it's important to note that we don't want to educate in terms of creating information and disseminating information that we're creating. With COVID-19 and the coronavirus, this is all a very fluid situation, and again, the topic itself is not one that an association would necessarily have any expert information on. So to the extent that the association is educating its residents, it's really going to just focus on disseminating information from local, federal, state authorities, not necessarily creating information. Always just remember to not go beyond the scope. So the number one question that we're getting from associations right now is, what do we do about our board meetings or our annual meetings? Right now, we're recommending that everyone cancel all in-person board meetings, and that really is in line with CDC guidelines and social distancing measures. It's really hard to have in-person meetings if you're next to each other and potentially exposing one another. In terms of single-family associations, luckily, Chapter 209 does address board meetings and provides associations the ability to hold electronic and telephonic meetings. Under Section 209.0051C1, the association, a single-family association, can conduct electronic and telephonic board meetings as long as the notice for that meeting provides the information on how to participate to the residents, and also as long as everyone can hear and be heard. And some of the platforms that we're seeing is that people are using for these types of board meetings are Zoom, which is what we're using today, GoToMeetings, Fast Conferencing. Microsoft Teams has a platform as well. So all of those options are out there, and again, the property code does provide for electronic and telephonic meetings to occur as long as the normal rules of open board meetings apply. Now remember, these are considered board meetings, and so normal rules do apply. That means homeowners should be able to participate in the sense that they can hear, they can observe what's happening. They may not necessarily be able to speak during the board meeting, which is, again, a normal procedure. If the board decides they want to have some type of a homeowner forum like they would in a typical in-person meeting, then they can certainly set up the platform to allow for a homeowner section as well. If the association isn't able to have a board meeting in the traditional sense where it can it can also have or take action in between board meetings. Now, the difference between the board meetings that I was referring to just a minute ago under C1 is that the association board can make decisions up to and including that list of 15 items that typically are reserved for open board meetings. And that list includes adopting budgets, initiating enforcement or collection actions, adopting dedicatory instrument amendments, borrowing or lending money. There's that list of 15 items that the board has to discuss and consider and vote on in an open board meeting. You can do those in the traditional electronic and telephonic sense if notice is provided to every homeowner. but you cannot consider any of those 15 items if it's an action that you're taking in between board meetings under section 209.0051H. And again, that's in chapter 209 of the Property Code. The only rules or surrounding the actions in between board meetings is that each board member has to have a reasonable opportunity to express an opinion. And then obviously if you do make a decision, then you have to summarize that decision in the next board meeting. Okay, in terms of board meetings for condos and high rises, there is an electronic and telephonic meeting provision in TUCA, that's the Texas Uniform Condominium Act, and that's chapter 82 of the Texas Property Code. It is a retroactive provision, so it applies to both chapter 81 and chapter 82 condos. But 82108C1 allows for board meetings to be conducted via electronic and telephonic means. There are also some limitations for high rises and condos in terms of what they can consider and vote on. The exclusions are voting on fines, damage assessments, and other similar items. Just refer to that provision for the specific list. In condos, section 82.108C2 does provide for unanimous written consent to still happen. And basically that means if the board in writing decides unanimously to take an action, then the association board can take that action. It has to be unanimous. And again, in 82.108C2, there are some exceptions which are similar to the exceptions in C1, and those are voting on fines and damage assessments. All right, we're going to toggle back and forth between Austin and I on these slides. So Austin, I'm going to let you take it away with annual and member meetings.
All right, hello everybody. So I'm talking about annual meetings of members and member meetings. So remember that those are different and have different rules. A lot of times there's confusion among my clients about what's a members meeting, what's an annual meeting in terms of what rules do we have to follow. In this case, we're talking about canceling physical members meetings. My opinion is that if you can cancel the meeting, you should, and I think that you have the legal right to do so. Now, that being said, under Texas corporate law, section 22-153 of the Business Organizations Code, the law says that the corporation shall hold an annual meeting at the time or as specified in the bylaws. Okay, so it's saying you have to do that. However, if there are extraordinary circumstances, it doesn't spell this out in so many words under the code, but in my opinion, such as a health pandemic, the board also is expected to use its common sense. Under the law also, section 222.208 of the Business Organizations Code, the corporation that is the association, as you know, is managed by the board of directors. And also under the law, 222.221 of the Business Organizations Code, the directors are required to discharge their duties in good faith, with ordinary care, and in the manner the director reasonably believes to be in the best interest of the corporation. So, in my opinion, I think that under the present circumstances, it appears more reasonable to cancel physical members meetings than to hold them. Now, there is an alternative, just like for board meetings, and that is you can hold electronic meetings. If the association's governing documents don't prohibit it, a Texas corporation can conduct members meetings by telephone or video conferencing technology. That's section 6.002 and section 22.002 of the Business Organizations Code. Section 6.002 applies to all corporations, and 22.002 applies to nonprofit corporations. So in order to hold these electronic meetings, the association must make sure that each person attending is able to communicate with all other persons participating in the meeting. Now we're going to go to the next slide, please. And if there's going to be voting at the virtual members meeting, then there must be a reasonable way to identify the members attending. You have to know that you're dealing with people who are authorized to appear at the meeting and to vote. And in addition, the association must keep a record of the vote. I think this may be a technological challenge to most associations. And I'm not going to say that you can't do it, but I would suggest that there are a number of third-party vendors out there who have the software to conduct electronic annual meetings and other members' meetings, that they already have been doing it before this pandemic came along. And their abilities include their ability to identify participants and record votes. So next slide, please. So community association functions. In this presentation today, we're going to review 3 primary functions of most community associations: the collection of assessments, deed restriction enforcement, and maintenance of common areas and amenities. Now I'll turn it back over to Zipper.
Thanks, Austin. Okay, in regards to collection of assessments, that's another big common question that we're getting from our clients, and most associations are asking if they should automatically suspend or defer collections. It's our advice that the association not just automatically defer, suspend, or extend all collections. We're going to talk about this a little bit later on, but we do think that portions of what community association businesses provide as services are essential services. And as part and parcel of being able to provide those services, the association has to be able to pay its expenses and potentially the employees and independent contractors that are going to be providing these services. And in order to do that, the association has to have its assessment income, which is really important. So we recommend trying to maintain business as usual and collecting assessments, keeping the due dates pretty strict as they are in your governing documents, whether it be January 1 or July 1, whenever assessments become due, or if it's a monthly assessment. We also are suggesting that an association be reasonable and act reasonably. So there are going to be residents out there that do reach out to the board and the management company about exceptions that they might need based on their particular situation. I think we have record highs in terms of people requesting unemployment. And so there are situations where employees are being furloughed and laid off. And it's our opinion that if a resident comes to you with a hardship situation, if they have been furloughed, laid off, or their budget for whatever reason just isn't allowing them to make the assessment payment, to consider a hardship exception and determine whether the resident should get a hardship. Again, it's most important to be reasonable. Don't automatically just defer and abate all collections for everyone. Take each particular resident that comes to you with a request on a case-by-case basis. Should you consider moving forward with foreclosure lawsuits or lawsuits in general for the collection of assessments? Right now, the courts are still operating, although they are operating in very limited ways. You can file lawsuits, and citations are being issued for process of service on those lawsuits. And I have a but there just because you have to be reasonable. This may not be, the best time to turn over 200 accounts and go after everyone. Just again, consider being reasonable, and certainly if you do file a lawsuit, again, keep in mind that consider some hardship exceptions if they come to you. Finally, for foreclosures and evictions, there is a 60-day suspension on all FHA insured mortgages currently. That HUD order doesn't apply to associations, but I know that there is a Supreme Court of Texas order that has currently halted evictions to a certain degree. You can file for an eviction and an eviction order may be issued, but you can't execute the eviction. So you can't physically really kick anyone out. That's really, that's coming from, again, the federal or state, and also some local levels. Some of the counties also suspended foreclosures. Some courts have suspended evictions because of the way that they are either able to operate or not. So just work with your attorneys on each one of these. You know, we are recommending that if you have a foreclosure set for April or even May, that you keep it set to keep the pressure on the homeowner to make sure that the assessment is paid so the association can continue to operate. But again, really important to be reasonable. Another function that the association does that we think is a pretty essential service in some respects, but not so sure if typical deed restriction enforcement right now is as essential as we all would normally think in terms of protecting and preserving property values. Again, I'm going to keep saying it, the association has to be reasonable. Austin mentioned the standard of care. You do have to act in the best interest of the association, but you have to also act in good faith and with ordinary care. I'm not so sure that right now doing deed restriction inspections is an essential service. And so you know, really what you're going to do is put pressure on people, especially managing agents or board members or officers, if you're going to require those, and that's probably not a good idea at this time. So I would certainly think about relying either on residents, or if you do have a person that's doing an inspection, maybe just every so often, just going forward with any deed restriction enforcement on very egregious situations. And by egregious, I mean if there's new construction going up without approval or something like that. Courts are hearing temporary restraining orders. And so if the association sees that there's some construction activity that hasn't been approved, reach out to your attorneys about maybe issuing a cease and desist, and then consider filing a TRO if you believe it's absolutely necessary. All right, Austin, back to you.
All right, thank you, Cipra. All right, so now we're going to be talking about maintaining common areas and amenities, one of the three primary functions of associations. And first, let me speak a little bit more about essential services. The term essential services is used in Harris County Stay Home, Work Safe order, and similar terms are used in other county and municipal orders. And here's a list of activities that are usually considered essential services: landscaping and grounds maintenance, pool maintenance, trash removal and recycling, streetlights, security services, and there very well are others that I haven't listed. All of those activities should remain operative, keeping in mind what appears in your mind reasonably to be an essential service. However, these areas should be closed. Swimming pools should be closed, not because the water itself might contain the virus, but because the areas around the pool are high-touch areas. The size of the pool, the ladder going in and out of the pool, the gates, the doors, etc. Also, let's look at recreation areas. This largely depends on what these activities are involved in those recreation areas. Many associations are leaving their outdoor spaces open to give people a chance to get outside, but tennis courts and basketball courts and similar activities are closed. Golf courses are staying open, but this may be subject to change. Gyms and fitness centers. Gyms and fitness centers are considered high-touch areas and should be closed and are ordered closed by most stay-home orders. Clubhouses are usually closed. So let's talk about, for a minute, controlled access and entry gates. Those should remain in operation because members have to come and go and vendors have to come and go and so forth. And you should simply be following your association's standard rules, but not trying to enforce stay-at-home orders or curfews. Okay. All right. So in this slide, we're talking about common areas and amenities for condos and high-rises. Again, you should close the pools, fitness centers, and community rooms. You should follow online CDC guidance to facilities and community areas for keeping common areas clean. You can find that on the CDC website for facilities. You should maintain valet and concierge services to the extent possible if social distancing and other precautions can be effective. Elevators. Obviously, elevators must remain operational and available because people need them. Equally obvious is that an elevator is a small space where social distancing cannot be adequately practiced. So the association must establish some rules, or I think should establish some rules for limiting elevator riders to 1 or 2 people, disinfecting the space, and so forth. Laundry rooms. People still need access to common laundry rooms, but the association should consider establishing rules that promote social distancing. Next slide. So this is a real tough one, right? So we're talking about positive COVID-19 cases. So what if you have a positive COVID-19 case in your community? I can guarantee you this is going to be controversial, but we don't believe that the association has a duty to disclose that information about confirmed COVID-19 cases or self-quarantines. In addition, we think that the association might have a duty not to disclose the information. It's not really within the scope of the association's duties, and it's best to allow local authorities to handle communication and the direction of individuals. Now, in some cases, associations are consulting with infected individuals to see if they're willing to make a disclosure, which they might do for purposes of transparency with their neighbors. Also, although community associations are not subject to HIPAA, be aware that the existence of HIPAA shows the seriousness with which many people take their private medical information. Back to you, Cipro.
Thanks, Austin. I'm going to stay on this slide for a second just because I have some stories that I wanted to share real quickly. I've had, a couple of situations where clients have reached out to me, both in the single family context and in the high-rise context, where in one of the residents had heard there was a resident returning from traveling abroad and they were self-quarantining, and this was in a high-rise situation, and so the residents were up in arms and they wanted to know what the association was doing. In another single-family context, the board had heard, and I'm not sure if this was, information that was factual, but that there were 2 positive cases, and those 2 individuals were isolated in the community. And once the board announced that, then the residents were up in arms and demanded to know who they were, and the residents felt like that information was important in order to protect themselves. I just want to again reiterate that that's really outside of the scope of the association, and as soon as you take on the duty to even notify people that there is potentially a positive case in the community or there are people that are under self-quarantine, you're going to get bombarded with additional questions. It's really best to let local, state, and federal authorities handle the situation, even the communication when it comes to that point. What we're suggesting is, and what the government is suggesting, is that you treat every situation like a positive COVID-19. Practice those social distancing and physical distancing rules, and pretend like everyone has it. And if you act that way, then it doesn't matter if there's one in your community or not, because you have to wash your hands for 20 seconds. You have to take those measures. Last night or 2 nights ago, there was a Woodlands apartment complex, an over 55 complex, that a judge basically in Montgomery County shut down. So let local government take care of any of those situations where maybe the community does need to be notified or extra precaution needs to be taken. Again, that's not within the scope of what the association should be doing. Okay, so back to shelter in place and stay at home orders. They're all slightly different, and they all have different timelines associated with them. So just take a look at them and read the one that's particular to your city or county. This is just a partial listing. Jesus, a longer list at the beginning. There's also a link to the State Bar website on this slide, and that has a list of all the shelter in place and stay at home orders. Again, just read the order. There's some questions from my clients, at least, about whether the shelter in place refers to or requires public places to close down their swimming pools and gyms and rec centers versus private entities like community associations. We're not a public governmental entity like a city of Houston that has a park. It's our opinion that the order applies across the board to all public and private entities, that you should be closing down, like Austin said, your pools and your rec centers and your gyms. And to the extent that we could be wrong, quite frankly, we think it would be almost impossible to practice social distancing or physical distancing if pools are open and rec centers and basketball courts are open. That 6 feet rule isn't going to be happening if those places are open. Not to mention that the type of work that it would require to maintain those facilities and constantly clean them after each use is probably very, very difficult to achieve at this time. One, because maybe the cleaning supplies aren't available. Two, you don't necessarily have enough employees on staff to maintain those guidelines. And so we are recommending that, that those types of common areas be closed. Remember, just try to think about whether or not that service is essential. And I know that's tough right now, especially when people are going bonkers at locked in at home. But if you don't have to provide the service, I would really rather not, so that we, again, stay away from liability. So in the shelter in place and stay at home orders, there are, for most counties and cities, provisions for essential businesses and activities to go on. What we are advising is that certain portions of community associations and management of those are essential functions and services. Not everything, but portions of it. We've kind of touched on some of this already, but certainly collecting assessments is an essential service in order to, one, maintain your common areas and your amenities per the CDC guidelines and pay your expenses. And then two, also to continue the essential services of maintaining your landscaping, cleaning your pool so that it doesn't become a health hazard, continuing janitorial services, trash pickup, security, and providing utilities. And then as it relates to community association essential functions that I've just talked about, any legal and accounting services should be able to continue to move forward. So that's a very short list. To the extent that an association or a management company can continue providing these essential services either remotely or with limited personnel, that's what we're recommending, because again, that one, limits liability, and two, flattens that curve and hopefully prevents the spread. If you have a question, again, this is a general presentation and our advice, but if you have a question, please reach out to your attorney before you think you are before you're about to provide an essential service. What you think or what the board thinks or what anyone else thinks might be an essential service isn't necessarily black and white. So check with legal before doing it so that you don't create liability. The stay in place or stay at home and shelter in place orders have criminal penalties for violations that include heavy fines and jail time. I know there's information out there that the police or law enforcement would prefer not to enforce them with jail time, and it's a last resort. But I think if people keep violating shelter in place orders, they're going to have no choice, especially if the spread continues at the speed at which it's going. All right, back to Austin.
All right, thank you, Super. All right, so this is a miscellaneous item. It's about employment. The Families First Coronavirus Response Act may apply to community associations, and if so, may apply to associations with as few as 1 or 2 employees. This is a new area for the act. I mean, the act is new, but I mean, for associations that only have 1 or 2 employees to have, these big federal acts applying to them is new and unusual. So you'll have to speak to your lawyer if you're planning on making an employment decision of some kind, um, if the act applies, associations may be subject to the requirements of paid sick leave, for instance, for employees, and the FMLA. The Family and Medical Leave Act allows eligible employees of covered employers to take unpaid job-protected leave for specific family and medical reasons, including the birth of a child, adoption of a child, caring for the employee's spouse or child or parent with a serious health condition, an employee's own personal health condition, and a variety of medical issues relating to service members' families. So if you're faced with a situation that might involve an employment question, like I said, be sure to contact your association's attorney before taking any action.
All right.
Next slide.
Yeah, I was just going to, sorry, Austin.
I said, unless you want to add something, I'm ready to go to the next slide.
Thank you. I was just going to add real quickly, my firm is disseminating information in connection with any labor and employment issues that are affected. So check LinkedIn and our newsletter or our website for information. Again, if you have questions, please contact your attorney first before you embark on, either doing something or refraining from doing something that might impact labor and employment issues. All right, so our final slide and general list of do's and don'ts. Austin and I are going to talk about these real quickly before we start talking about these. Jesus, do you want to tell everyone how to submit a question for question and answer either through the chat, or did you say that already?
I did, and I can read those, and I've also messaged them to both you and Austin individually.
Okay. Perfect. Austin, take it away with the do's.
Okay, so I'm covering the do portion of this page. Do follow the guidance and orders issued by federal, state, and local authorities. They are essentially our standard of care, and we want to make sure that we follow them closely. Close most common areas, as we've discussed earlier. Encourage social distancing. And I would add disinfect things when you can. One second. All right, we also talked about digital technology to have members meetings and board meetings and take board action. My clients are regularly doing the board meetings and the board actions electronically now since this whole thing started. I think it's been a little bit more of a challenge to do the members meetings, but that also can be done. I think we all could use some fresh air and exercise during this crisis, so do get that. Communicate with your members, continue essential operations, and follow the standard of care recommended, demonstrating your prudent business judgment. And finally, consult your attorney to determine how these suggestions fit with your governing documents and your community. Now to Cypher.
All right, I've got the pleasure of talking about don'ts. Don't hold in-person board meetings or member meetings. Again, I know that there's CDC guidelines about, I guess you can operate or have meetings as long as it's, or gatherings as long as it's 10 or less people. I'm suggesting, we're all suggesting that even if it's 10 and under, that you just continue holding in-person meetings, just again to help flatten the curve. And you just never know where any of those other 9 people have been and the people that they may have been in contact with that could potentially put you at risk. Don't cause panic in your communities, and that just is in line with watching the type of information you're disseminating, working with your attorney on that communication, and not disseminating too much information. Again, remember to stay within your scope, which protects you from potential liability if you're operating outside of your standard of care. don't overstep your scope, which is what I just talked about. Remember that our scope or our main purpose is to preserve and protect property values. We can certainly help disseminate information, but don't try to go beyond that. And then, as Austin mentioned, don't forget to call your attorney for advice. I know some of y'all are operating under very skeletal situations or skeletal staff, and you don't have the means necessarily, but pick up the phone and call us and ask us for any advice before you take on some type of action and potentially expose the association to liability. I think that's all we have. I'll go to the next slide and then turn it over to Jesus. Thank you.
Yeah, thank you, Austin and Cipra, for your expertise. I know we're 1 minute over, but our contact information, as I mentioned at the beginning, contact information is there. We will email this PowerPoint out to you along with the survey. We'll also post it on our YouTube so you can click back and review it in video recorded format. We've developed a site with resources for the coronavirus for our members. So please feel free to check that out, caihouston.org. And so right now what I'll do is I will go to the questions, and I think Cipra and Austin, you may have those in front of you. If you look at the bottom of your screen, there's a chat button. We got a couple of questions from the audience, if you guys wouldn't mind answering those.
I have one question regarding TROs. If the association needs a TRO, are the courts there to be able to accomplish that filing? Yes, courts are hearing TROs. We haven't had to do one yet, so I'm not sure exactly how that process is working, but we do know that they are happening.
All right, I see one also. The question was open or close the tennis courts. I think, yes, the tennis courts need to be closed. I mean, you have people that are handling those tennis balls back and forth. You hit it to me, I usually miss it, so I have to pick it up and handle it to hit it back to you. So I just think the tennis courts should be closed.
I will mention that while I was out at a City of Houston park this weekend, the City of Houston law enforcement came and roped off the tennis court. So they are closing public tennis courts. So I think that that's probably an indication of what local government thinks about leaving those open.
Okay. And Cipra, you've got one more. You may see it in there.
I have another question about what associations should do if the purpose within the Articles of Incorporation is to provide for the health and safety and welfare of the residents. And I touched on this a little bit. Quite frankly, I think even if that's a purpose, the association has to operate very carefully and again, not disseminate more information than it really needs to sufficiently, operate within its scope. I would just recommend that if that is in your Articles of Incorporation, that you work with your attorney and kind of tweak any communication that you might be sending out so that it's in line with that purpose or that scope.
Well, that's all we have. Again, I want to thank everyone for your time and thank you for logging in and listening to this presentation. It's a new format for us. I think it's the first time we've ever done it. So if there were any kinks, we apologize, but it seemed to work pretty smoothly. Hopefully we can do more about them. Hang on a second. Oh, how about taking temperatures at the back door? I'm not quite sure. Maybe we can answer that one post webinar unless you want to take it now.
I'm going to say no. That's not. I mean, what part of that is within the course and scope of most associations? That's really not within your role. I mean, what do you do if someone does have a temperature? You demand that they go to the doctor. I don't know. It really goes, I think, way beyond what the association should be doing.
And additionally, we're not really aware of all the health protocols that are required to carry that function out. And what happens if our employees get sick doing it? I just think there's the potential for liability, and it's really outside our purpose.
I have one more. Wants to take a poll for the management companies that are participating in the webinar to see if you're doing inspections. How many management companies out there are continuing with inspections as normal? I guess if you can either respond via chat to Jesus or we can get that information.
Yeah, we seem we're about done. Let me unmute everyone, and then we can. There we go. So if anyone wants to respond to that.
This is Shelley. We have about 2,000 homes in our neighborhood, and we are expecting folks to mow their yards. So that's about all we're doing, though.
You are unmuted. You are unmuted.
Anyone else continuing inspections?
No, we're not.
We are currently not, but just wanting to know if others are still doing it and what they're doing it for.
We have one comment that says amenities are locked. We're only inspecting the major mechanicals.
I'm sorry, Jesus, you broke up. What did you say?
We have one comment. The amenities are locked, and they're only inspecting the major mechanicals.
Got you. Sorry.
High-rise buildings. And another person commented, some we've suspended and some just driving and citing serious issues.
Well, I'll say that there are some deed restrictions that actually read that if the unapproved improvement is completed prior to a lawsuit being filed, then it's deemed approved. So we do have to kind of pay attention. Now, maybe that can be done just by the members themselves since everybody's at home. But we do have to be generally aware of what's going on in the neighborhood, I think.
Mm-hmm.
This is Jennifer. We have about 300 homes right now that are occupied. We're doing inspections as far as unauthorized requests that are being completed by the homeowners. So serious issues.
Right.
I think some management companies out there are, from what I've seen, utilizing some interesting tools where residents in the community can upload a picture or, complain about a neighbor that might have some type of a violation. So that was the purpose of my deed restriction enforcement slide, is to try not to be nitpicky at this time, but to the extent that you feel like you need to, certainly we're not going to let grass grow and not be maintained for 3, 4, 6 weeks, however long we're under this shelter-in-place order. Just remember to be reasonable, but you can certainly utilize those tools and rely on residents to get some of the deed restriction issues if it's important enough.
Okay. All righty. Well, thanks again, everyone. I think we'll cut it there. And I just want to give a real quick plug. Fingers crossed that the restrictions don't go on into mid to late summer. But we do have our Take a Manager to lunch on July 23rd at the Omni Houston West Side. So hopefully we can continue with that. And we'll send out some information, save the date, and all that here in the next few weeks. Thanks again. And if anybody has any questions, you can reach either one of us right there. Or call. So appreciate your time.
Thank you for doing this.
Thanks all.
Thank you.
All right. Thank you, everybody.
Thank you.